Welcome to Manika IAS. In this video, we'll be discussing about Article 16. In the previous video, we discussed Article 15, which was essentially dealing with the matters of discrimination on certain basis as well as special privileges which were given to socially educationally backward classes. Now in this article, the Article 16 is dealing with equality of opportunity in matters of public employment. So whereas that particular article was talking in general, this particular article is saying that there should be equal opportunity for everyone when it comes to the public employment. That means any sort of employment or appointment under any office in the state. That means in very simple term, government jobs, right? So there should be equal opportunity for all to participate in the government job, obviously subject to certain qualifications. You can have different set of qualification criteria that you see for every government exam which is there. Other than that, there should be equality in opportunity, right? That means if say in civil services, the primary is qualification criteria is you should be a graduate, then anybody can sit for the exam. There is no discrimination on the basis of gender, sex, place of birth, religion, region, caste. No discrimination. If you are graduate, you have that qualification, you can sit for the exam, no matter you are qualified in arts, you are qualified in say science or any subject, you can still sit for the exam, give the exam with same passion. And we have seen that from varied classes in caste and religion and region, you have civil servants in India. So that means there shall be equality of opportunity to all citizens in matter of employment or appointment to any office under the state. No citizen shall, on the grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. As we discussed, you cannot discriminate the citizen on the basis of religion, on the basis of race, on the basis of caste, sex, descent, place of birth, residence, or any of them. Apart from this, as we discussed, like on the basis of qualification you can make, because eventually the efficiency of services have to be maintained. That's why you have qualification criteria, because you need to maintain efficiency. You cannot just ask anyone to give any exam. You need to have that scientific temperament to be eligible for that particular exam. That's why we have certain bare minimum qualification, but you cannot discriminate on these bases. However, Article 16 clause 3 says that the Parliament can make laws in regard to classes of employment within the state or union territory, any requirement as to residence within the state or union territory prior to such employment or appointment. It says that in certain circumstances, residence can be made the basis of any sort of reservation or discrimination. Basically you can give certain privileges to certain people of residing in certain places, right? So to give in fact to this government employment public employment requirement as to Residence Act 1957 was passed. It reserved job of classes 3 and 4 for local residents in states of Andhra, Himachal and Manipur. However, when they saw that now there is social parity, because it was to give effect to the some sort of social disparity, they wanted to create a balance. So in extraordinary circumstances, residence can be made in order to uplift the people of particular place. So that is why it was made. However, it was later removed. And in the recent time, Haryana also has made a law which is trying to secure or save some jobs in the private sector for the people of Haryana itself. However, the matter is sub judice. It is yet to be seen what decision that the Supreme Court will come up with. However, it can be made as a basis on in certain extraordinary circumstances. Other than that, there is no such law which is presently active, which is creating jobs on the basis of residence. So as of now, there is no such law which is active in the country. Then coming to Article 16 Clause 4, it says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizen, which is in the opinion of state is not adequately represented in the services under the state. Now this particular article is again an enabling clause, and as we discussed in Article 15, that the previous this previous clause as well, Clause 3, Clause 4, these are enabling provision, whereas 1 and 2 are fundamental right. Why these are enabling provision? Because these are not mandatory. State can make a law, right? State must not make a law, right? So state can make a law if they feel that there is a need. These are to create a sort of equality, a sort of parity, to bring in social equality, economical equality. The agenda is this only. Okay, so these are enabling provisions. And what is the difference between 1 and 2 and 3 and 4? In case the government tomorrow decides that there is no need of such law, so you cannot just go to Supreme Court on the basis ki it is our fundamental right, we need to have certain reservation. No, reservation is not a fundamental right. It is just a supportive measure basically, So however, if tomorrow government goes and discriminate on the basis of say race and religion in terms of public employment, you can go to the Supreme Court saying it is a violation of fundamental right. But if tomorrow government decides that we are not going to give reservations, you cannot go to Supreme Court saying that our fundamental right has been violated. Although in other parameters, Supreme Court can take a decision, but not on the basis that your fundamental right has not been taken away by that. No, because it is not your fundamental right, right? So these are enabling provision. Now, what is this saying? That in public sector jobs, you can make a reservation for the classes, backward classes, which in the opinion of state are not adequately represented. If the government think that a class is not adequately represented in the jobs, then government can make reservation for those sectors of job, sections of job. So we have seen that we have reservation for OBCs, SCs and ST. A collective 50% reservation is there, right? Now, what happened in 1979? Morarji Desai, the then Prime Minister, set up a second backward class commission under BP Mandal. And this commission recommended that 27% of government jobs are to be reserved for the OBCs, right? Which at that time 23% seats were reserved for SC and ST. So the total reservation will go up to 50%, right? Then in 1990, VP Singh implemented the recommendation of Mandal Commission, and it gave 27% reservation to OBCs. Coming to 1991, the Narasimha Rao government gave another 10% reservation to economically backward section. Economically backward section. However, if you read this particular provision, it means that if they are socially and educationally backward, if they are not adequately represented, right? So in 1992, in Indira Savani versus Union of India case 1992, which is also referred to as Mandal case very often, the Supreme Court, although upheld the introduction of Article 14, however, it also had held that this reservation is unconstitutional. And this was a landmark judgment when it comes to your reservation policy. So remember this name, because it is very important for your reservation policies. It upheld Article 16 Clause 4, but however, it held this 10% reservation as unconstitutional. Further, it introduced conditions to give reservation, when and why to give reservation. It says you can only give reservation if the community is socially or educationally backward. And that is why in 2015, when Ram Singh versus Union of India case went, which is very famously known as Jat community case, when Jat asked for reservation, in the public sector jobs, then the court said that no, they are not socially or educationally backward, so it will be unconstitutional if we give them the reservation. So their reservation was called off. So in that particular case, it took away the reservation for Jat community, saying that they are socially and educationally not backward. Second, if they are not adequate representation, if there is no adequate representation, saying that adequate representation does not necessarily means proportional representation. Say for example, if the population of a certain section is say 10% and you are saying they should be having 10% of jobs, no, that is not the case. The proportional does not imply adequate representation. It is a very subjective term where Supreme Court decide on the basis of quantifiable data that whether they are adequately represented or not. It is very subjective, subject to the Supreme Court, and it is the job of the government to present the data to the Supreme Court, and Supreme Court will then, or higher judiciary will then decide whether they are adequately represented or not, right? Third thing it says is overall reservation shall not exceed 50%. That means, as we discussed, the EWS reservation was called off because it was going beyond 50%. So it created a ceiling that you cannot go beyond 50%, right? And this is also known as vertical reservation rule. Okay. Now the other thing is that whenever you are giving reservation, it shall not affect the overall efficiency as per Article 325. Article 325 says that reservation shall not impact the efficiency of the work. So that is why efficiency has to be taken in consideration. Then second last thing is it introduced the concept of creamy layer, and it says that since a large population of OBCs are also socially and educationally not backward, so you need to introduce the concept of creamy layer, and it is the non-creamy layer. That means the educationally and socially backward OBCs and not the uplifted one who should get the benefit of the reservation and not them. So you have to create a creamy layer. So the concept of creamy layer was introduced, right? Now Article 16 Clause 4A, it says nothing in this article shall prevent the state from making any provision for the reservation in matters of promotion with consequential seniority to any classes of post in services under state in favor of scheduled caste and scheduled tribe, which in the opinion of state are not adequately represented in the state. Now this was added by 77th Constitutional Amendment 1995 after the Indira Savani judgment. And then there are three things that you need to remember about this. Is it is giving reservations in promotions. Second, it is giving reservation in promotion only to SC and STs, not OBCs. Third thing is, and it also introducing the concept of consequential seniority. What does that mean? That means, say if there is a hierarchy and an SC and ST is given privilege over the general candidate, in promotions. Now in further promotion also, that SC ST candidate will consider as senior above the general who was earlier senior, right? So if they are giving promotion above general, for the next time they will SC ST will only be considered as a senior candidate, and that is referred to as consequential seniority. Now this was taken to the Supreme Court when the introduction of this article then again was taken to Supreme Court, and in M. Nagaraj versus Union of India 2006, the Supreme Court held that this particular is valid. This introduction of this particular article is valid. However, it is subject to three conditions. First, as we discussed, they have to be adequately representation, and then the state has to establish the backwardness of the category, right? And then efficiency. However, in Nagaraj Case 2018, the Supreme Court again said that there is no need of quantifiable data to prove the backwardness. That means it has done away with this provision that now state is not liable to prove the backwardness of the caste, right, in giving promotion, reservation in the matters of promotion. Now we had discussed that reservation policy means not more than 50% of reservation. There are certain exceptions to this vertical reservation policies. So Tamil Nadu reservation policy, it reserves 69% of seats and posts for the people of in their state, right? However, post Indira Savani judgment, Tamil Nadu was forced to reduce to 50% the entire reservation. Since the Indira Savani case, the Supreme Court held that the reservation cannot go par 50%, right? So they were forced to bring it down to 50%. However, again in 1994, Tamil Nadu reservation of seats for BC Act was put in place, and it was placed in 9th schedule. Now, what is so special about the 9th schedule? 9th schedule, along with Article 31A, as we discussed when we were discussing fundamental rights, previously, were introduced in the Constitution by very first Constitutional Amendment Act in 1951. And as per Article 31B, this schedule is not subject to the judicial review. That means any act which is placed under 9th schedule cannot be questioned in the court of law, right? Now that is why when Tamil Nadu made this act, which was exceeding the 50% of reservation, they put it in the 9th schedule so that it cannot be questioned in the court of law. However, in IR Kolo versus State of Tamil Nadu 2007, Supreme Court said that 9th schedule is subject to judicial review if the provision are against the basic structure doctrine. So we discussed about the basic structure doctrine, right? So it says that 9th schedule is also subject to judicial review, subject to basic structure. If the laws are not in sync with the basic structure, if they are going beyond the basic structure, destroying the basic structure, then they are subjected to the judicial review. However, it also says, since the doctrine of judicial review was introduced in Keshwananda Bharati case in 1973, 24th April, so the laws which were put in place in Schedule 9 before this date are not subject to judicial review. However, the laws which were placed in 9th schedule after this cutoff date, that is after the Keshwananda Bharati judgment in 1973, the laws are subject to judicial review and they cannot go beyond the basic structure of the Constitution. Now, another thing is carry forward policy. Article 16, Clause 4B. It was introduced in 81st Constitutional Amendment 2000. It reserved the seats if vacant. Say for example, there are 100 seats which were, say, in 2022, which were there reserved for SC and ST. Now out of them only 90 were filled and 10 were vacant, right? Now these 10 will be carried forward for the next year. say in 2023, right? So 100 seats again are there for SC ST, and these 10 seats will also be carried forward for SC and ST. Now the total seats will become 110, right? That means this vacant seats are outside the ceiling of 50% for that particular year. Although also 16 clause 6 reserved the appointment of or post in favor of economical weaker section of citizens, as we discussed in Article 15 clause 6. Similarly, this was also introduced by 103rd Constitutional Amendment Act, and it reserved the seats in the favor of economical weaker section to an extent of 10%, which is over and above the ceiling of 50%, which is yet to be decided by the Supreme Court, whether it is constitutional or it is non-constitutional. The matter is still sub judice. We'll see when the results will, any verdict will come on this particular topic. But as of now, the reservation stands there. Still there are reservations for EWS, right? So next we'll discuss Article 17 and Article 18. Till then, you read these articles. These are very important articles. If you have any doubt, any question, please ask in the comment section below. Thank you and have a nice day.